Hi, my name is Zach McGee. I'd like to welcome you to the latest installment in our Stand-Up CLE series, where we repeatedly attempt the impossible, teaching you something about the law while being slightly more entertaining than your average CLE program. As we are fond of saying here at Stand-Up CLE, we like to set the bar as low as possible. The topic of today's program is the lawsuit that the cast of the cult classic film This is Spinal Tap, Rob Reiner, Michael McGee, Christopher Guest, and Harry Shearer, recently filed against French entertainment conglomerate Vivendi, its subsidiary Studio Canal, and Studio Canal CEO Rob Halpern. In their complaint, the actors allege that the defendants failed to pay them their fair share of profits from the film in general, and from exploitation of the film's music and merchandise in particular. For example, the actors claim that according to the accounting statements they received from Vivendi, their total share of the profits from sales of the film's music between 1989 and 2013 was only $98. Geez, I knew the music business was in trouble, but I'll go out on a limb here and say that seems low. On the other hand, maybe Vivendi sold 100 million copies of the Spinal Tap soundtrack, and 999,990 copies were returned once people realized that Spinal Tap is not a real band. You see, the movie This is Spinal Tap is a mock documentary, now famously known as the first mockumentary, about an aging rock and roll band from England who is in the midst of a US tour to support their latest album, provocatively titled Smell the Glove. You may be familiar with some of the more recent mockumentaries, many of which star some of the same actors from Spinal Tap, such as Best in Show, A Mighty Wind, and of course, Gone with the Wind. In Spinal Tap, Reiner plays the fake documentary film's director, Marty DeBerge. McGee plays the band's lead singer, David St. Hubbins. Guest plays lead guitarist Nigel Tufnell, and Shearer plays bassist Derek Smalls. The tour does not go well, causing the band to break up, and then later to make up, just in time to launch a tour of Japan where their new song, Sex Farm, is a surprise hit. Although McGee, Guest, and Shearer steal the show, and impressively wrote and played all of the instruments on the music from the film, that includes the songs Hellhole, Give Me Some Money, and Stonehenge, the film includes appearances by several other well-known personalities, including comedians Billy Crystal and Dana Carvey, TV sitcom actress Fran Drescher, and musician Paul Schaefer. This is a good time to stop you and say that if you haven't seen Spinal Tap, you need to stop watching this program and go watch it now. I cannot in good conscience allow you to continue to go through life without having seen this awesome film. Until you see it, you'll continue to miss out on all the clever references people around you are making, day in and day out, to some bit of dialogue from Spinal Tap. For example, you have no idea why My Lawsuit Goes to 11 is funny until you've seen the movie. Besides, I'd rather you not laugh at my jokes because you don't think they are funny, which is understandable and puts you in good company, and not because you have no idea what I'm talking about because you haven't seen Spinal Tap. While we cannot give you CLE credit for the time you spend watching Spinal Tap, it would be pretty sweet if we could, wouldn't it? But the CLE board, spelled B-O-R-E-D, would not let us. But we can make it very easy by reimbursing you for the cost of renting the film on your favorite online video on demand service. Instructions for how to watch the film and be reimbursed for your rental are appearing on your screen now. We thought this would be a nice thank you gift for viewers of today's program. Kind of like Oprah giving each member of her audience a car, albeit a car that's only worth $4. And that is a cheap car, ladies and gentlemen. Even in Prague, where legend had it that in the 1990s, you could trade your Levi's for a car. I wonder how all those Czechoslovakians feel now some 30 years later, still walking everywhere because they have no cars left, but still looking good in those acid-wash jeans. We also decided to give our viewers the chance to rent Spinal Tap on us because, based on the allegations in the complaint, it sure sounds like Vivendi and the cast both could use the extra money. So please, go now, watch Spinal Tap, laugh it up like a stoned hyena, and come back when you're ready to get started. Howdy, stranger. Welcome back. Was that movie just awesome or what? As if I needed anyone to validate my taste in movies. Any Tropic Thunder fans out there? Spinal Tap holds a 95% certified fresh rating on Rotten Tomatoes, and it is on many film critics' lists as one of their all-time favorite films. Do you remember the film critic Roger Ebert, who was one half of the weekly TV show Siskel and Ebert, along with Gene Siskel, that was popular in the 1990s when Spinal Tap was released? Each week on Siskel and Ebert, two white, middle-aged Chicago area film critics would give a brief summary of each movie, that was coming out that weekend, but no spoilers, because that probably would have been enough to get you an FCC complaint in the wholesome 1980s, followed by a usually cranky review of the film and an overall thumbs up or thumbs down recommendation on whether or not you should go see it. In those days, it only cost $5 to see a movie, so why wouldn't you go every weekend? Oh yeah, because minimum wage was $3 an hour. And to get a bag of popcorn, you still had to give the guy at the concession stand your entire wallet, and he would give back what he didn't need, just like today. Never mind. Siskel and Ebert was sort of like an early version of Facebook. If the only people on Facebook were middle-aged white men liking each other's posts, which, come to think of it, is pretty much like Facebook today. Sorry, Dad. Ebert gave the following glowing review of Spinal Tap. Quote, "Rock musicians never die, they just fade away. And This Is Spinal Tap is a movie about a British rock group that is rocketing to the bottom of the charts. It is also one of the funniest, most original films of the year. The movie looks like a documentary filmed during the death throes of a British rock band named Spinal Tap. It is, in fact, a satire. The rock group does not really exist, but the best thing about this film is that it could. The music, the staging, the special effects, the backstage feuding, and the pseudo-profound philosophizing are right out of 100 other rock groups and a dozen other documentaries about rock. The movie is absolutely inspired in the subtle way it establishes Spinal Tap's badness. The satire has a deft, wicked touch. Spinal Tap is not that much worse than, and not that much different from, some successful rock bands. A few breaks here or there, a successful album, and they could be back in business. You may know that Roger Ebert, the much cooler horse of the Siskel and Ebert quinella, died recently after a long battle with throat cancer. By contrast, Gene Siskel is still hanging around, sticking his raised thumb in places it doesn't belong, which doesn't seem like cosmic justice to me. On the other hand, in 2002, the Library of Congress designated Spinal Tap, quote, culturally, historically, or aesthetically significant, and selected it for preservation in the National Film Archive, over dozens of other, much more pretentious films like Citizen Kane and 2001: A Space Odyssey, which seems like cosmic justice to me. So what is the gravamen? I always loved that word, gravamen. Learning that word was worth half the price of admission to law school, of the actor's complaint against Vivendi. To shorthand it, the actors have a contract that requires Embassy Pictures, which through many assignments and corporate machinations is now part of Vivendi's Studio Canal unit run by CEO Rob Halpern, to pay them a share of Vivendi's profits from its exploitation of Spinal Tap, including the film's music and merchandise. And they allege that Vivendi is breaching that contract and committing fraud by not accounting to or paying them fairly. We'll get into the details of all of this shortly, but you should recognize at the outset that the Spinal Tap lawsuit is a classic Hollywood profit participation case where writers, actors, and/or directors claim that the studio has failed to give them their fair share of a studio's movie's profits. Typically, the talent claim that a studio has taken a film that grossed $100 million or more at the box office and transformed it into a modest success or even a net loss by the studio's willful manipulation of its books, a practice colloquially referred to as Hollywood accounting. Here, the Spinal Tap actors claim that they've been cheated out of millions in profits by Vivendi and seek in their complaint a total of $400 million in compensatory and punitive damages, while Vivendi claims that they are not entitled to a dime more than they already have been paid. So I guess you could say the parties are pretty close together in how much they think the case is worth? I have a lot of experience with profit participation cases that I will detail in a moment, but you don't need any experience to speculate that, as with most lawsuits, the truth probably lies somewhere in the middle. If the parties want to hire me as a mediator, I'm sure I can get this baby split and the case settled right now for a cool $200 million payment to the actors. I'd be happy to take a small fee in the nature of 1% for my close analysis of the facts and the law that made such a creative and fair settlement possible. Any takers? Going once, going twice? Oh well. In my prior life, I was a litigator, and when I worked in-house, I was a litigator at NBC Universal, where I defended the TV studio primarily in profit participation cases. I handled high-profile lawsuits brought by David Cohan and Matt Muchnick, creators of the NBC comedy Will and Grace, the actor Kevin Sorbo, who played Hercules, the actress Lucy Lawless, who played Xena, Warrior Princess, the actor Jack Klugman, who played Quincy, and many others. Yes, Hercules and Xena both sued the studio, claiming they should have made more money than they already did for acting in those terrible series. It turns out, though, that bad acting is a complete defense to profit participation claims. Just kidding. It's a complete defense to an Emmy nomination. Later, when I was head of business and legal affairs at Miramax, I was involved in profit participation lawsuits over the film version of The Hobbit and over the Oscar-winning film The English Patient. It turns out that the only thing that lasted longer than the 3 Hobbit movies or The English Patient were the lawsuits over The Hobbit and The English Patient, and neither of those even had an appeal. And the only thing sadder than the ending of The English Patient is finding yourself at work on a Sunday night writing a letter about some documents you absolutely must receive in discovery, and a few paragraphs later about some documents that the other side absolutely cannot require you to produce. To quote Charles Dickens, "The law is an ass." Each case I handled at NBC Universal and Miramax was different, and each case turned in large part on the language of the contract at issue. But I can tell you that in the approximately 10 years I handled profit participation lawsuits and claims, while there is a perception in and around Hollywood that studios routinely engage in Hollywood accounting, I've seen some profit participation claims that have merit, others that have no merit, and everything in between. You simply cannot generalize, either that all studios engage in Hollywood accounting on every film they produce, or that all talent are greedy bastards who try to take advantage of the perception of Hollywood accounting to allege fraud where none exists. And each case needs to be analyzed on its merits. Like Fox News, if it told the truth and was useful, my goal today is to give you a fair and balanced assessment of the claims and defenses that are being raised in the Spinal Tap lawsuit, based on my experience and my review of the pleadings, which are included in your materials, along with the contract the plaintiffs signed for their work on the film. I'll also provide some necessary background on how Hollywood movies are financed and distributed, and how the proceeds from that distribution generally are accounted for to talent who have a profit participation in a film. For starters, the term profit participation is a misnomer, because it almost never entitles talent to a true share of the studio's profits, as the term profits is normally understood by accountants and business people who are used to generally accepted accounting principles, or GAAP. A profit participation is more accurately described as a contractual right to receive payments from a studio contingent on the results of the distribution of a film rather than a share of the film's profits that a co-owner or a joint venture with the studio might receive, which in that case likely would be calculated on a GAAP basis. I'm also going to try to be reasonably funny while doing all of this, which is much harder than the legal stuff, but at least with Spinal Tap, we've got some great raw material. This leads me to a couple important disclaimers. First, I have no inside information about the Spinal Tap lawsuit. Everything I know is from reading the complaint and, to date, Vivendi's motion to dismiss, and I'm basing my analysis solely on the pleadings and my experience as a former in-house litigator who handled many cases involving similar claims. Second, the contract between the actors and Embassy Pictures, which at the time was a small independent film studio and not one of the major or mini-major studios where I've worked, is unique in many respects, and my analysis of it isn't going to be applicable to other contracts between other actors and other studios, particularly the kind of talent that would enter into with NBC Universal, Sony, or even Miramax, which for a time was owned by Disney. Third, nothing of what I'm discussing today has anything to do with my current job at Sony Pictures Home Entertainment, where I serve in a business and non-legal role as head of business affairs. In that role, I have nothing to do with profit participation claims or disputes involving Sony, and you can imagine I'm pretty happy about that. In fact, I come to work every day with a smile on my face, thinking about all of the discovery that I no longer have anything to do with now that I'm a recovering, as opposed to practicing, litigator. Everything I'm going to say here is based on my prior experience when I was a litigator who handled profit participation claims and disputes while working at NBC Universal and Miramax, and none of it is based on my work at Sony. None of the views I express are the views of my current or any former employers, and I'm speaking solely for myself as part of the CLE program. Fair warning though, I do plan in this presentation to capture the sights, the sounds, and the smells of a hotly litigated profit participation case, so you may want to consider that before continuing. I also have no interest in the Spinal Tap case other than a purely academic one, both because it involves one of my favorite films and because it exposes a lot of mistakes that were made, both by the actors and Vivendi, if the allegations in the complaint and the motion to dismiss are true. Next, if you are a fan of our stand-up CLE series, or its companion series Sit Down CLE for when we presenters get tired, you're used to getting legal ethics credit for viewing one of our presentations. Today's program is a general CLE credit program. Wait, did everyone just leave? I know everyone really needs ethics credit, but you also need general CLE credits, more of them actually, so why not stay a while? Yes, that's it. Come on back in the pool. The water's warm and not just because someone's kid peed in it. Okay, good. The audience is back to get some general CLE credit while having a reasonably good time learning about profit participation lawsuits. Finally, I'm obligated to say that no animals were harmed in the filming of today's presentation, although a few were politely told to shut their beaks and stop pooping on the carpet. So, without further ado, and in keeping with my fair and balanced review of this case, who are these greedy actors who dare accuse warm and cuddly French conglomerate Vivendi of fraud? The first plaintiff is Rob Reiner, who is famous for a great many things besides writing, directing, and acting in the sublime Spinal Tap. Reiner also directed the incredible movie The Princess Bride, and if you think in doing these presentations that I often lack charm, I can assure you that I mean you no harm. We can't afford to send you to another free movie, but that's another film that must be part of your comedy vocabulary. In addition, of course, to the absolutely hilarious The English Patient. Reiner also directed A Few Good Men, which probably inspired a lot of people who didn't know what to do with their lives, either to go to law school or to join the military. And many of those people were killed, so thanks a lot, Rob. Reiner first became famous playing Archie Bunker's son-in-law, Michael Stivic, on All in the Family, who was nicknamed Meathead in the 1970s. Now, 40 years later, Reiner laments that he still can't escape being associated with his most famous character, having quipped that he could win the Nobel Prize and the headline would be, Meathead wins the Nobel Prize. That's a damn funny line. I think I'll use that myself to get a laugh, and I just did. Winning! Reiner is also known for his liberal politics and political activism. Since the 2016 election, or as many people call it, the sixth sign of the apocalypse, Reiner has continued to campaign against Donald Trump, apparently not realizing that the election ends the campaign. That's what an election is. What a meathead. Actually, Reiner is a very intelligent human being, having called President Trump racist, anti-Semitic, and anti-gay, and having compared him to the Nazi police at Auschwitz. Oddly, none of this offends Mr. Trump as long as nobody insults his hair or his very tiny, childlike hands. Ladies and gentlemen, our next plaintiff is Michael McGee. Like Reiner, McGee got famous by playing a character on a hit 1970s TV series. In McGee's case, he played Lenny Kozlowski, who along with David Lander, who played Andrew Squiggy Squigman on the series Laverne and Shirley. Later, McGee made his way to Saturday Night Live, where he had the distinction of being the oldest person at 46 ever to join the cast until Leslie Jones recently joined at age 47. What a coincidence, because Leslie Jones and Michael McGee are so similar I frequently get them confused. Like Spinal Tap, who has earned a distinguished place in rock history as one of England's loudest bands, Leslie Jones is SNL's loudest cast member. That's a Spinal Tap joke. I hope you stopped to watch the movie and didn't cheat on me. You cheated on me, didn't you? I told you not to watch this program without watching the movie first, and I even offered to pay for it. I'm disappointed in you, Mary Beth, very disappointed. But I get where you're coming from. After all, mime is money. Okay, that's another Spinal Tap joke that you're not getting because you didn't watch the movie. So please, go watch and come back. That's why God invented the pause button. Okay, welcome back to Plaintiff Michael McGee. McGee also currently holds the distinction of being the only SNL cast member to first have appeared on the show as both a musical guest and a host before becoming a cast member. Obviously, many cast members have later gone on to host the show, including Jimmy Fallon and Tina Fey, both of whom are from Boston, which, as everyone knows, is not a big college town. Again, I hit you with a Spinal Tap joke when you weren't looking. I hope you did your homework and didn't cheat on me. We're on the honor system here, people. Our next plaintiff is Christopher Guest, whose real name is Christopher Hayden Guest, 5th Baron Hayden Guest, as he is actual British royalty. Technically speaking, he holds a hereditary British peerage as the 5th Baron Hayden Guest, which in other words means that he probably has hemophilia. But for most of us, we think of Christopher Guest as royalty because he played the evil six-fingered Count Rugen in The Princess Bride. Hello, my name is Inigo Montoya. You killed my father, prepare to die. Which of course is another famous line from Spinal Tap. No, it isn't. That was a trick to trip you up. It's really from The Princess Bride. You refuse to watch Spinal Tap, even when I offer to pay you for it. I'm giving up on you, Mary Beth. Your pop culture education is no longer my concern. Guest is pretty awesome for many reasons, in addition to the fact that he is English royalty adjacent. First of all, he's married to Jamie Lee Curtis, who is very hot if you remember her from Trading Places and True Lies, and maybe a little less hot if you remember her from the Activia Keeps You Pooping regular commercials. Second, he appears along with Martin Short in that classic SNL skit where Guest and Short play synchronized swimmers. You can have as much Christopher Walken and more cowbell as you want, but for my money, give me Christopher Guest and Martin Short swimming together in that pool any day as one of the best SNL skits ever. Third, Guest has starred in every one of the excellent mockumentary films that followed Spinal Tap, including Waiting for Guffman, Best in Show, A Mighty Wind, For Your Consideration, Family Tree, and Mascots. If you're interested, Guest's Wikipedia page features a chart showing which other actors have appeared in which of these films, from which you can discover truly interesting tidbits, such as Jane Lynch appeared in Best in Show, but not Waiting for Guffman. Very interesting. Why do these wiki nerds spend their time on this, and why can't they get real jobs? I'm sure Mom's basement is a reasonably close bus ride to the local Walmart if you want to get out and see some actual people. Despite his accomplishments on film, there are some indications that Guest may not be the nicest guy in real life. A reporter who interviewed him put it this way, quote, "On film, Guest is a hilariously droll comedian. In person, he is serious and almost dour." The reporter quoted Guest to reply, quote, "People want me to be funny all the time. They think I'm being funny no matter what I say or do, and that's not the case. I rarely joke unless I'm in front of the camera. It's what I am in real life. It's what I do for a living." That's interesting because I'm the complete opposite. I'm funny in person and not so much on camera. This is actually a good segue to our final plaintiff, Harry Shearer, who by most accounts is not a very nice person in real life, despite being another amazingly talented film and TV actor in his work life. Shearer also was in most of the other documentary films, check Guest's Wikipedia page to find out which ones, and also a cast member and a writer on SNL. But he's most famous for voicing some of the most iconic characters on The Simpsons, including Mr. Burns, Smithers, Principal Skinner, Ned Flanders, Reverend Lovejoy, and Kent Brockman. Excellent, Smithers, excellent. Release the hounds. I don't think anybody can say those character names and not be tempted to do your own impression. Sorry, mine is pretty bad. By contrast, Shearer has voiced these characters for almost 30 years and is so talented, he can do scenes where these characters talk to each other in a single take, switching back and forth between voices in real time. According to Shearer, he learned how to do voices from the legendary Mel Blanc, the voice of Bugs Bunny, Daffy Duck, and Barney Rubble, who took him under his wing. What's up, Doc? Again, terrible impression, but too hard to resist. I think it was a bad idea for me to incorporate impressions into my presentation. You know what they say, it's such a fine line between stupid and clever. Shearer was the first actor to sue Vivendi over Spinal Tap, with the other actors joining a few months later. And it's fair to say that Shearer was the instigator and is the main protagonist of the litigation. In addition to being the first to lawyer up and sue, Shearer is also litigating his claims in the court of public opinion, having posted a video on the website www.fairnessrocks.com in which he explains his decision to sue Vivendi. He also recently gave a detailed interview that appears in the June 2017 issue of GQ magazine, where he is quoted as saying that he and the others have been effed over by Vivendi and issues a warning to Vivendi, "I'm like a dog with a bone." He also is quoted as saying about Vivendi, "Do they believe their own financial statements? Because if they're believing what they send us, I think they need medical attention." Suffice it to say, it's always risky to try your case in public because once you open that Pandora's box, you can't close it again. Might someone post a video showing how much money Shearer has made in 30 seasons of voicing Simpsons episodes at an average of $250,000 an episode? I think that number might have a B in front of it instead of an M. Or someone might write an article detailing all the mistakes that the plaintiffs, their agents, business managers, and lawyers made in failing to look out for their own interests by, for example, never once auditing Vivendi's books, which they always had the right to do, and waiting many years before filing a lawsuit over the money they claim they're due. These mistakes may well prove fatal to their lawsuit seeking to recover against Vivendi now. This is also not the first time Shearer has had a nasty falling out with a studio. According to Dick Ebersol, who was in charge along with Lorne Michaels of SNL at the time Shearer was working there, Shearer was fired due to creative differences, but also for being, quote, "a gifted performer, but a pain in the butt. He's just a nightmare to deal with person," end quote. For his part, Shearer shot back saying, "When I left, Dick Ebersol issued a press release saying creative differences, and the first person who called me for a comment on it read it to me, and I blurted out, 'Yeah, I was creative and they were different.'" That's another funny line. I think I'll use that one for another cheap laugh. Just did. Winning! Shearer has had several disputes over the years with Fox over his pay on The Simpsons, repeatedly refusing to work unless he got a raise in his per episode fee, which at one point was as high as $400,000 an episode. A broadcast television season typically consists of 22 episodes, so you do the math on that over almost 30 seasons. In a way, it's hard to begrudge someone as talented as Harry Shearer as much money as he can negotiate for his unique talents. But it also strikes most people as piggish to be walking out unless you get $400,000 an episode and not a penny less, particularly when you are part of an ensemble cast of dozens of actors who voice characters on the show. I'm sure Shearer will not make a possible settlement with Vivendi in the Spinal Tap case any easier if and when those conversations start happening. If Vivendi is lucky, Harry will at some point simply explode on stage and no longer be a problem for them, since, as we all know, dozens of people spontaneously combust each year. It's just not really widely reported. So enough about the plaintiffs. Let's meet the defendants in the case. They are Vivendi, a large French media conglomerate, Vivendi's subsidiary, Studio Canal, and Studio Canal's CEO, Rob Halpern. Before Vivendi acquired Embassy Pictures, the studio that produced Spinal Tap, Embassy Pictures had a long and bizarre list of corporate owners that included Coca-Cola and L'Oreal, to name just a few. Not sure what corporate synergies the geniuses at Coke or L'Oreal had in mind when they bought Embassy Pictures. Buy Spinal Tap on DVD and get a free can of Mr. Pibb, or perhaps some Rouge to go with it? It's sort of like when GE bought NBC and Universal Pictures. I remember going to these GE corporate legal conferences where I met lawyers from other GE divisions like aircraft engines, plastics, and GE Capital. It's not often as a lawyer that you get to feel like the cool kid, but when I went to these conferences as a lawyer at a film and TV studio, I felt pretty cool next to the guy whose job it was to draft contracts to sell plastic. But feeling cool is always relative. Now that I work at Sony Pictures, I feel pretty cool until I'm in an elevator with the people who work at Sony Music, and man, are those cats cool. They dress like they're in a music video all the time, and they smell really good. Too bad no one is making any money on music these days, because music people really seem to have a good thing going over there. Why do you suppose poor Rob Halpern got named individually as a defendant? The complaint includes some allegations about a meeting Halpern had with Harry Shearer, where Halpern allegedly misrepresented to Shearer Vivendi's plans to distribute Spinal Tap on DVD, but ordinarily something like that wouldn't be enough to state a claim against Halpern as an individual, as opposed to stating a claim against Studio Canal because Halpern was acting in his capacity as its CEO. My guess is that the plaintiffs named Halpern as a defendant in an effort to trigger Studio Canal's directors and officers insurance policy and potentially access that policy for possible settlement discussions. Ordinarily, studios would not have insurance coverage for breach of contract or fraud claims like the ones being alleged here, and thus they would be required to pay their own legal fees and any judgment the plaintiffs might obtain. By naming Halpern personally, the plaintiffs appear to be seeking to access Studio Canal's D&O insurance policy in a case that ordinarily would not be covered by insurance. The Spinal Tap lawsuit is in its early stages, so we're years away from a jury trial. In fact, U.S. District Judge Jolly McGee of the Central District of California has yet to issue a substantive ruling in the case, although a decision on Vivendi's motion to dismiss is expected any day now. Even if Judge G grants that motion, it won't dispose of the lawsuit because the issues before her on the motion relate to things like standing and whether plaintiffs can state a claim for fraud, separate from their claims of breach of contract. This is bad for the defendants, who will be dealing with Harry Shearer for at least the next several years, unless, of course, he spontaneously combusts or dies in a bizarre gardening accident. But it's good for me since it should give me plenty of material for future installments of this program. Because I'd like to be helpful to Judge G, and because ever since I clerked I've secretly wanted to be a federal judge, except for the salary of course, and truth be told, black isn't my best color, I'm going to offer my list of the top 5 reasons the defendants are screwed in this case, followed by my top 5 reasons the plaintiffs are also screwed in this case, based on my experience handling profit participation cases and my review of the pleadings and the contract between the plaintiffs and the defendants at issue here. Judge G, if you're watching this program, although I can't imagine why you would be since judges don't need CLE credit, and if you follow my advice, you can winnow down what I am sure are voluminous legal briefs filed by both sides to a few key points, craft a ruling that essentially says a pox on both your houses, and engage in some serious baby splitting that would make King Solomon proud. For everyone else, I hope to give you a few key insights into how the film business works so you can join me in scratching our collective head as we try to figure out how so many sophisticated parties got themselves into such a huge mess in this high-profile case. All I can hope is that at the end of my presentation, when you are filling out your evaluation form, you give me a better review than the critics gave Spinal Tap on their album, The Gospel According to Spinal Tap. Quote, "This pretentious, ponderous collection of religious rock psalms is enough to prompt the question, what day did the Lord create Spinal Tap, and couldn't he have rested on that day too?" Before we can explore how and why everyone involved in the Spinal Tap case screwed up so royally, we need to talk a little bit about how feature films get made, financed, and distributed. Let's say you had a great idea for a new movie. Something like this. Looking for any way to get away from the life and town he was born into, Trip, a high school senior, builds a monster truck from bits and pieces of scrapped cars. After an accident at a nearby oil drilling site displaces a strange subterranean creature with a taste and talent for speed, Trip may have just found the key to getting out of town with a most unlikely friend. Okay, so that is not a great idea for a new movie. That is actually the plot of Monster Trucks, which was one of this year's biggest flops. It reportedly cost Paramount $170 million to make Monster Trucks, but the movie earned less than $65 million at the box office, worldwide. But of course, no one knows that going in, except for this movie where anyone with half a brain, and unless that person also happens to drive a monster truck to work, should have known that this was a colossal stinker from the get-go. But let's say that you had the idea for Monster Trucks and wanted to make it into a movie, but somehow you lacked the $170 million in your bank account that you would need to make that happen. What would you do? The answer, of course, is that you would go out and pitch your idea to a movie studio, and if they bought it, they would take your idea for a movie and make it into an actual movie. But what's involved in that Faustian bargain? Well, it's actually a pretty good deal for the writer. First, the studio will pay you an upfront fee to write the script for your movie. Even for a first-time writer, that upfront fee is nothing to sneeze at. The WGA, the Union for Writers of Feature Film Screenplays, mandates that the studio pay you at least $130,000 to write your original screenplay. And they also are required to pay you more if you do additional writing, such as polishes or rewrites of your script. Not bad for someone whose best idea for a movie is Monster Trucks. You also likely will get a separate upfront fee for helping to produce the movie based on your script. And if you act in it and or direct it, like the plaintiffs did in Spinal Tap, you get separate upfront fees for that too. The rates for all of these things are set by the guilds in terms of minimums, and they will be considerably higher for writers, actors, producers, and directors who have credits on prior films. Hollywood works on a quote system, so if you earned $130,000 as a fee for your first script that was a total flop, you are likely to receive $130,000 plus 10% for your second script, because you know it's your second script. If you ever wondered why some movies are so bad, it's because the writer of that movie got paid 10% more to write the script for that movie after his last one failed. I think our industry rewards failure more than Bill Cosby when he was telling us how great New Coke was. Wait, you're booing me? Did something happen to Bill Cosby? Is he okay? A rapist? Really? Like 100 women? Holy snikes, I need to get out more. As they say in late night infomercials, but wait, there's more. Writers, actors, and directors who work on feature films often also get a profit participation in the film, which is a contractual right to receive additional compensation based on the profits the studio makes from distributing the film. And it is this profit participation that is in dispute in the Spinal Tap case. A profit participation can be worthless for a film like Monster Trucks that costs far more to make than it will ever earn back, or it can be very valuable for highly successful films and film franchises like The Lord of the Rings or the Harry Potter series. The concept is that if a film does well enough for a studio to make a profit, it should share some of that profit with the people who helped to create the film. The problem is that most films don't turn a profit for studios once all the costs of making and distributing the film are taken into account. And remember, when a studio makes your movie, they take on all of the costs of making it and distributing it, including bearing all of the risk of failure. In the case of Monster Trucks, Paramount can't go back to the writer and ask him to chip in to help cover some of its $100+ million in losses. In fact, as we learned earlier, that writer gets to move on to his next project where he'll earn even more money for his next script, despite having made all of us a little bit stupider by virtue of now having learned the plot of Monster Trucks. Paramount alone bears that risk and those losses when it chooses to produce a movie that it then owns for better or for worse. With regard to how Paramount could possibly have greenlit the colossal stinker that was Monster Trucks, I think best to leave that mystery unsolved. But how can studios spend so much on a movie such that earning even $65 million at the box office doesn't generate a profit? Let's look at an example of a highly successful film that some journalists have pointed to as an example of Hollywood accounting, the fifth film in the Harry Potter series, Harry Potter and the Order of the Phoenix. According to press reports, Warner Brothers reportedly earned $612 million in global box office from this film, but was reporting a net loss, i.e. the opposite of net profits that would be shared with profit participants, of $162 million. Based on those same press reports, the math worked out like this. Warner deducted $211 million off the top as its distribution fee, roughly 35% of the total, $313 million as the cost of making the film, $58 million in interest on those production costs, $131 million to publicize the film, and $61 million in distribution expenses, leaving a net loss of $162 million on a film that the general public would label a monster hit. Here's how Harry Shearer describes what he calls the business model of the major studios. Quote, "Here's your budget. It's a loan at prime plus 2, and then we'll do your distribution for a fee of 30% off the top, and all of our costs are chargeable against you. It's ludicrous. No one else in the world could get away with it." David Mamet, the famous playwright, included these lines in Speed the Plow, his satire on the movie business. Quote, "Two things I've learned 25 years in the entertainment industry. The first one is, there is no net, as in net profits, and I forget the second one." And so are they right? Is this all just a big scam? In a word, no. The problem with Harry's logic is that Spinal Tap was not his movie once he made the decision to sell his movie to Embassy Pictures, which in turn paid all costs to make it, publicize it, and distribute it, while at the same time paying Harry and the other plaintiffs upfront fees for writing, acting, and composing music for the film. As wealthy as Harry is today, I'm betting that back in 1982, when Spinal Tap was produced, he didn't have 2 nickels to rub together, much less access to the $3.5 million it cost to produce the film. There would be no Spinal Tap without Embassy Pictures, and it's only in success that profit participants like the plaintiffs here come back seeking a huge payday as their fair share of what they claim was the studio's profits. Nor did young Harry have any leverage back in 1982, as every major studio turned down his pitch for Spinal Tap, until Embassy Pictures, which was founded by Norman Lear, who created All in the Family, starring that meathead Rob Reiner, decided to take a chance on the film. And how much did Spinal Tap earn at the box office? $4.7 million. So not a hit by any means, at least in terms of its theatrical run. What's more, if Spinal Tap had never been made, there is a very strong chance that Harry, Michael, Christopher, and Rob would not have had the success that they've enjoyed in their subsequent careers, and instead would be currently residing in the "where are they now" file. But wait, you say, what about all the crazy high fees and costs we saw with Harry Potter and the Order of the Phoenix? Is that legitimate? In a word, yes. In 2 words, yes and no. While it's possible, and probably likely, that an audit of Warner Brothers would have uncovered that some fees and costs were overstated, and when you're talking about $750 million in fees and costs, even a 5% rounding error would be almost $200 million, which in itself would be enough to swing the movie from a net loss to a net profit. These categories of expenditures are completely legitimate. Production costs are out-of-pocket costs the studio actually pays to produce the movie. For a movie like the 5th installment of the Harry Potter franchise, you can see Warner Brothers spending that much on the cast, the sets, the locations, the special effects, etc. The same is true for the amounts Warner Brothers spent to publicize the film. Think of all the TV and print ads that Warner's ran globally to promote each installment of the Harry Potter series, which they knew would be a hit if they could make sure people were aware that the next installment was being released. If a 30-second ad during the Super Bowl can cost $1 million, it's not surprising if Warner Brothers spent $131 million globally to promote the next Harry Potter movie. As for interest on the production costs, if the studio had borrowed money to cover those costs from a bank, it would have paid interest on those funds from the date they were borrowed until the date those loans were repaid. Because Warner Brothers chose to fund the production costs itself instead of borrowing them from a bank, it is entitled to earn interest on those amounts until they are repaid from revenue generated by the film, just like a bank. Distribution expenses are like production costs after the film is made, but before it can be distributed. For example, in order to release Harry Potter and the Order of the Phoenix in Spain, Warner Brothers needed to create a Spanish language version, with Spanish language marketing materials rated by the Spanish Film Board, as well as hundreds of physical prints of the film to distribute to the various theaters in Spain. And we all know how hard it is to teach magical creatures how to speak Spanish. And that is just for one country for a film that was released theatrically in every country in the world that has a movie theater. Distribution expenses also include the costs associated with distributing the film later on DVD, on television, and in digital media like iTunes, Amazon, and Netflix. As you can expect, these costs can get dialed up very quickly, and in some cases, like with a huge film like the 5th Harry Potter movie, they can even go up to 11. But that doesn't mean these expenses aren't necessary or legitimate. And like production costs, distribution expenses are out-of-pocket costs paid by the studio that need to be recouped before a film generates any real profit for the studio. Distribution fees are a subtler concept, as they are not out-of-pocket expenses, but rather a proxy for the overhead that studios must maintain in order to make, publicize, and distribute a film. Major studios employ thousands of people who work to make, publicize, and distribute feature films. Rather than allocate and deduct their actual overhead, which would be messy and constantly changing as folks are hired or leave, studios take a fixed percentage of revenues, ranging from 10 to 50%, as a distribution fee to compensate the studio for use of these in-house resources. As much as Harry Shearer rails against a 30% off-the-top distribution fee, as we will see shortly, he specifically agreed in his contract with Embassy Pictures that Embassy could charge distribution fees ranging from 20 to 50% on revenues generated from Spinal Tap. To paraphrase Spinal Tap, I'm not saying that Harry's memory is fading. No. I just think his memory is becoming more selective. With this background, and without further ado, I present to you the top 5 reasons the defendants are screwed in this case. Embassy Pictures and Vivendi have dug themselves a huge hole out of which they will need to climb if they are to prevail in this case. Some of the mistakes they made have been repeated by other studios in other cases, while others seem pretty unique to this case, such as allowing their trademark registrations for the name Spinal Tap to expire. The number one reason the defendants are screwed in this case is no arbitration provision. All major motion picture studios require talent to arbitrate disputes arising out of their contracts with the studios, particularly disputes over their profit participation. That is because every studio has been burned by a large profit participation case that did not require arbitration, that went to a jury trial, and the jury awarded the talent a huge sum. When I was at NBC Universal, I handled 2 large profit participation cases, each of which was equally meritless in that the talent already had been paid many millions of dollars as a profit participation, but was coming back for more, claiming that the studio breached that contract in various ways. In the case that went to mandatory arbitration, NBC Universal was handed a complete victory by the arbitrator, who saw through the smoke and mirrors offered by the plaintiffs and applied the contract's clear terms, even awarding some costs and fees to NBC Universal for its trouble. On the other end of the spectrum, the other case went to a jury trial in Los Angeles Superior Court. Same situation, same meritless claims, but this time the jury came back not only intending to award the plaintiffs millions more in compensatory damages, but also considering awarding punitive damages for fraud. That case settled shortly thereafter, but the difference between a jury trial and arbitration and profit participation cases cannot be more clear. If you take these cases to a jury, you most likely will lose, and lose big. And if you take them to an arbitrator, you most likely will win. It doesn't take the genius writer who came up with the idea for monster trucks to see that arbitration is key for studios to require in these cases, and Embassy Pictures completely missed the mark on that here. I think Vivendi's only hope now is to offer some serious prayers to St. Hubbins, the patron saint of quality footwear. Apart from having a strong bias in favor of creative talent and against movie studios, in no small part because of the perception of Hollywood accounting perpetuated by the press, the other major reason juries can't get these cases right is that they are too complex for lay juries to understand. A profit participation definition, which is purely a function of the contractual terms that the 2 parties agree to and not based on any standard finance definition of profit, and as a result, it is a highly complex and confusing animal that only people who know this area well can interpret with confidence. Juries are so completely lost that they tend to just give up and vote for the party they like more, which is almost always the little guy writer or actor and not the big guy studio. In fact, in cases where 2 studios have sued each other over profit participation claims, which is rare but it does happen from time to time, such as the case that small producer Celador brought against Disney over profits from the Who Wants to Be a Millionaire TV series, where Celador won a $319 million jury verdict against Disney, it's almost always the little guy who prevails over the bigger guy, even if the little guy is also a studio. A litigator I know recently tried a profit participation case to a jury, and during deliberations, one juror wrote down a question and presented it to the judge. The judge stared at it, completely baffled by the question, so he called the lawyers in with a single juror to ask him to explain it. The question he wrote on the note was, quote, "How long was the plaintiff in the hospital?" It turned out that this juror had heard so much about recoupment during the trial, in terms of which costs the studio had recouped from its revenues, which he thought meant the same thing as recuperation from an injury, that he was wondering how long the plaintiff had been in the hospital. That's the level of understanding of the complexities of profit participation cases that you are dealing with on most juries. And like a rock band wearing tight pants and sporting armadillos in their trousers, that is something about which every studio facing a jury trial in one of these cases should be very afraid. In Embassy Pictures' defense, arbitration was not that common back in 1982 when the Spinal Tap contract was negotiated, and profit participation litigation was not yet established as a huge risk for studios like it is now. Still, the fact that their contract does not require the plaintiffs to bring their claims in arbitration has the potential to turn loser claims, ones that an arbitrator would see through and quickly dismiss, into winners, and potentially huge winners. That is probably why the plaintiffs thought they could get away with their ludicrous $400 million demand in a case where the film made less than $5 million at the box office. Some crazy LA jury might actually award them that much after worrying about how long poor Harry, Christopher, Michael, and Rob had been in the hospital. Of course, any award of that size would be vulnerable on appeal, but in most instances, Vivendi first would have to post a bond in order to take that appeal, which for a $400 million jury verdict is not an easy thing either. The pressure to settle a case like that, where such a jury award is looking possible or even likely as the trial progresses, or worse still for Vivendi after it has come down, is a huge problem for the studio and one that the defendants may not be able to overcome, no matter how good their lawyers are or how strong their defenses are to the actual claims being made. The number 2 reason the defendants are screwed in this case is no clear contract. While Embassy Pictures actually required the plaintiffs to sign their contract, which doesn't always happen, particularly when dealing with older films where some deals were made on handshakes followed up by deal memos, the problem is that they allowed the entire standard terms and conditions to that agreement, which includes most of the profit participation definition, to be subject to good faith negotiations between the parties. See paragraph 13 of the contract attached to the complaint. This happens a lot in studios, less so now than in the past, but it's driven by careless business affairs executives and lawyers who want to be able to close their deal without having to actually deal with all the legal provisions at the back of the contract. The problem with this strategy in contracts that include profit participations is that these legal provisions contain most of the provisions that protect the studio when participants want to challenge how the studio is distributing their film and accounting to them for that distribution. For example, Embassy has some great language in their profit participation definition that says that the studio has no duty to exploit the film. See paragraph 5.02 of the contract attached to the complaint, which is the language that protects a studio when a participant comes back and says, "Why didn't you sell my film in China?" or "Why isn't it on Netflix?" But since the Spinal Tap plaintiffs never agreed to the profit participation definition, they agreed only to discuss Embassy's proposed definition in good faith, it seems unlikely that Embassy will be able to enforce these provisions against them, at least not in their current form. The other reason this error is so problematic is that it is hard enough for a studio to win a profit participation case in front of a jury against creative types when you have a contract that everyone agreed to, much less one where even the words in the contract are not deemed to be final or binding on the parties now, some 30 years later. In those cases, the jury, and probably even Judge G when she is called upon to resolve motions to dismiss, will be forced to default to what is fair or what the parties would have agreed to following good faith negotiations. That is never going to result in a studio being able to enforce the sort of provisions that it typically would rely upon to defeat claims seeking to second-guess its exploitation of a film. Once again, Vivendi is in a world of hurt in this case due to another rookie mistake that was made right at the outset. The number 3 reason the defendants are screwed in this case is no affiliated party transactions disclaimer. Among the key protections that studios include in their profit participation definitions are provisions that allow the studio to use its affiliates to distribute the film without a requirement that the terms of those deals be at arm's length or on fair market value terms. While this may seem dodgy, is it the studio's goal to do deals with its affiliates on below market terms? The intent is actually benevolent in that if you think about it, no studio can ever deal with an affiliate at arm's length because they share common ownership. And since the transaction at issue isn't likely to be sent out for bid to third parties in the market, there's no way to establish that the terms to which the studio agreed with its affiliate reflected fair market value. Put another way, if Embassy Pictures ended up licensing Spinal Tap to a TV network that was owned by its parent company, absent an affiliated party transactions disclaimer, that license always would be open to attack by participants, claiming that Embassy didn't negotiate with its affiliate at arm's length, and as a result, it ended up giving the affiliate a sweetheart deal, whereas an unrelated TV network would have had to pay more. This is another key defect in the contract between Embassy Pictures and the plaintiffs that will make it much harder for Vivendi to defend any transactions involving Spinal Tap that were done with affiliates. Once again, in Embassy Pictures' defense, this contract dates back to 1982, when, for the most part, studios, including the major motion picture studios, were not part of media conglomerates that owned not only the studios that produced feature films and TV series, but also TV networks and other platforms where that content was exhibited. As such, affiliated party transactions were not a big part of a studio's distribution plans for a feature film, and thus were also not a big risk area for studios like they are now. The other major difference is that in 1982, there was no such thing as home entertainment. Your only option to see a feature film was in a theater, and then approximately 3 years later when it would be broadcast on network television, which seems crazy to us now. The rise of the VHS tape followed by the DVD changed all of that, and it also created a huge source of revenue for all of the studios that they generally exploited through each studio's affiliated home entertainment division. As such, affiliated party deals also became much more common, and fast forward to today, are a significant part of the revenue picture for most feature films. While Embassy could not have foreseen the rise of home entertainment back in 1982, the lack of an affiliated party transaction disclaimer, combined with the fact that most of the profit participation definition at issue was not final but instead subject to good faith negotiation, creates a very tough road to hoe for Vivendi. The number 4 reason the defendants are screwed in this case is no work for hire language. It is boilerplate in every studio's agreement with every writer that the script he or she is writing for a feature film is being written, quote, as a work made for hire for the studio, and that the studio is the writer's employer for purposes of the copyright law. The reason studios include this language is to make sure that the studio owns the copyright in the script written by the writer, and more relevant for the Spinal Tap lawsuit, that the writer will not be able to terminate that grant of copyright ownership when the copyrighted work might otherwise become eligible for termination. The rules on when an author can terminate a previously granted copyright are complex, and they depend in part on when the work was written, and thus which version of the Copyright Act applied to the work, and a discussion of those rules is beyond the scope of today's presentation. It also would be very boring, and we aim to entertain, or at the very least, not bore you to death. Suffice it to say, Embassy Pictures missed the boat again on this one by failing to include standard work-for-hire language in its agreement with the Spinal Tap plaintiffs, which may well give them the ability to terminate that grant of copyright in the characters that were used to create the film. The situation here is even worse for Embassy, because unlike an original idea for a feature film that has its first expression in the form of a screenplay written specifically for that feature film, the Spinal Tap movie was based on characters that the plaintiffs created some years before, and they created a short film that they presented to Embassy as part of their pitch for the film. Furthermore, because most of the dialogue in the Spinal Tap movie was improvised, the plaintiffs created a detailed backstory for each character and rehearsed various scenes, but the final film was performed by the actors without using an actual script. While that made the world's first mockumentary appear even more real, it made the copyright ownership situation even worse for Vivendi, which doesn't even have a script that it can claim was written specifically for Embassy Pictures as a work for hire. Plus, they have pre-existing characters and a short film created by the plaintiffs that both predate any employment relationship between the plaintiffs and Embassy. All of this adds up to potential trouble for Vivendi in that it strongly suggests that the plaintiffs may be able to terminate their grant of exclusive rights under copyright to the Spinal Tap characters they created to Embassy Pictures, which would leave them free to use those characters without Vivendi's permission. Now, in a bit of good news for Vivendi, even if the plaintiffs were able to terminate their grant of copyright to the Spinal Tap characters, Vivendi would still own all rights to the movie This Is Spinal Tap, and it could continue to exploit it freely. A termination of copyright ownership does not change the ownership of derivative works that were produced prior to the effective date of the termination. What it would mean is that Vivendi could not create any more derivative works based on those characters, such as a sequel, because it no longer has ownership of the copyright in the Spinal Tap characters, which is required to create future derivative works based on those characters. That isn't much of a loss for Vivendi. As great as This Is Spinal Tap is, no one is clamoring for a shoddy sequel. And since you couldn't do a sequel anyway without the participation of the original cast, who are, by the way, suing you, it's kind of a moot point. While Embassy did a lousy job of making sure it was acquiring all rights to the Spinal Tap characters and the short film created by the plaintiffs, and ensuring that their work on the film itself was a work for hire under copyright law, this was a pretty unusual fact pattern for a feature film, a mock documentary that was improvised and not scripted, based on pre-existing characters created by the actors, that was in some sense unprecedented. In addition, copyright terminations for feature films did not become a big risk area for studios until the early 2000s, when the heirs of some authors of some famous works, including the author of the original Superman comic books, succeeded in terminating those copyrights, which endangered the right of certain studios to produce additional feature films featuring characters like Superman. Undoubtedly, Embassy should have done a better job securing copyright ownership of the Spinal Tap characters, but in the grand scheme of things, with no sequel planned, it's the least of their current problems. Finally, the number 5 reason the defendants are screwed in this case is no trademark renewals. When you produce a feature film, you want to be sure to trademark the name of that film so that you can use that name in, among other things, merchandise for the film, soundtrack albums for the film, toys, games, etc. Embassy Pictures managed to cover off the first part of that okay, but they allowed these trademarks to expire, which no studio in their right mind would ever do. In fact, studios have entire teams of lawyers whose job it is to manage the studio's trademark portfolio to ensure that something like that doesn't happen, and to take steps to enforce the studio's trademarks in the event someone else files a competing mark. Even at a small studio like Miramax, we took great care to make sure we kept our trademark registrations current, not just in the US, but in the EU and other key markets for our key titles. This is where Vivendi was literally asleep at the switch, not only allowing their own trademarks to the name Spinal Tap to expire, but they failed to take steps to try to block others from filing trademarks for Spinal Tap for things like the name of a new beer. This is Studio Legal 101, and Vivendi's lawyers seem to have failed that course. Of course, in his zeal to reclaim as much of the rights to Spinal Tap characters as possible, Harry Shearer has since filed his own trademark application for Spinal Tap, as well as for Derek Smalls, the character he played in the film. Vivendi is now in the awkward position of trying to oppose Shearer's trademark filings and assert their right to demand a license and payment for him for any use of the name Spinal Tap, all of which they could have avoided had they simply kept their trademark registrations current. Once again, losing their trademark registrations for Spinal Tap is unlikely to be fatal to Vivendi, since they could still be able to use the name Spinal Tap in connection with their exploitation of the film and merchandise related to the film, but they will no longer be able to block others, including Harry Shearer, from using that name too. Pretty soon you may be able to purchase 2 official Spinal Tap concert t-shirts, one authorized by Vivendi and one by Harry Shearer, which is another weird possible outcome of this bizarre case. Okay, so the defendants are pretty screwed in this case, but in a funny twist, so are the plaintiffs. Here are the top 5 reasons the plaintiffs are also screwed. The number 1 reason is, don't forget the statute of limitations. Although the plaintiffs in their complaint were being purposefully vague about the last time they received a profit participation statement from Vivendi for Spinal Tap, their allegations suggest that one was issued to them sometime in 2014. The contract they signed with Embassy Pictures stated in Section 4 of the Standard Terms and Conditions that the plaintiffs, quote, shall be forever barred from maintaining or instituting any action or proceeding based upon or involving or in any way relating to or pertaining to or concerning any transactions had by Vivendi or its sub-distributors in connection with the film and the accounting embraced in any statement or account delivered there, unless such written objection thereto is given Embassy within said 12-month period, and such action is commenced within 6 months after the delivery of the said written objection. That is a monster of a sentence even for lawyers. I love that they said, quote, in any way relating to or pertaining to or concerning any transactions, as if something could relate to a transaction but not pertain to it or concern it. Nice work again, Embassy lawyers, you really nailed on that one. So this very long sentence is what is known in profit participation cases as an incontestability clause. These clauses limit a profit participant's ability to challenge accounting statements issued by the studio to some period that is shorter than the normal statute of limitations that would apply for breach of contract, which in California is 4 years. Because the plaintiffs failed to send Vivendi a written objection to the statement they received in 2014 within 12 months thereafter, Vivendi will have a strong argument that they are now barred from challenging that statement. The need for these clauses is to force participants to raise timely objections to accounting statements so they can be investigated and addressed by the studio while the relevant records still exist and the relevant people who are involved still work at the studio. These clauses also force participants to exercise their contractual audit rights in a timely fashion so they can have a basis to make their written objection to the accounting statements they received, which the plaintiffs here also failed to do. The idea that the Spinal Tap plaintiffs can bring a claim in 2016 relating to the distribution of a film that started all the way back in 1982 and force Vivendi to provide records supporting its accounting statements dating back some 35 years, having never before exercised their contractual rights to audit, is patently unreasonable. That is why I think it likely that Judge G will toss out most, if not all, of the plaintiffs' claims based on the incontestability clause. That said, there is some hope for the plaintiffs because, as we noted before, the incontestability clause resides in the Standard Terms and Conditions, which was left open to good faith negotiation and not in the main agreement. As such, it's possible Judge G will find that a 12-month incontestability provision is not reasonable and decline to enforce it. However, even applying the 4-year statute of limitations applicable to breach of contract claims in California, she almost certainly would limit the plaintiffs to challenging Vivendi's distribution of the film occurring within the last 4 years, which again would severely limit the amount of damages the plaintiffs could claim, even if Vivendi were found liable. Put another way, the plaintiff's $400 million claim might be a $400 claim if it survives at all. So for all their bluster about Vivendi's Hollywood accounting and fraud, Harry, Christopher, Michael, and Rob very well might lose their case because they, their agents, and their business and legal representatives were asleep at the switch, failing to take action when Vivendi sent them accounting statements and failing to read the contract they signed that required them to object and sue promptly over the amounts reflected in those statements or forever hold their peace. The number 2 and 3 reasons the plaintiffs are also screwed is those terms are outrageous, so why did I agree to them? While there is some debate about whether the standard terms and conditions, which were left open to good faith negotiation, can be enforced against the plaintiffs, there is little doubt that the terms of the main agreement that they agreed was final and they signed is binding on them. Unfortunately for the plaintiffs, nearly all of the outrageous fees and other terms about which they now complain are set out in the main agreement, or alternatively, are specifically referenced in the main agreement as being, quote, non-negotiable, end quote, parts of the otherwise negotiable standard terms and conditions. Take the plaintiff's complaint about failing to see much money from film merchandise. In paragraph 5, the plaintiffs specifically agreed that only 5% of revenues from merchandise would be included in the pot in which they participate, which is a pretty standard provision in many deals where the costs of producing the merchandise are not deducted either. So it's effectively a royalty model where the participants get 5% of the gross instead of a larger percent of the net. With regard to music from the film, the plaintiffs specifically agreed that Embassy Pictures would own the publishing rights to the music and that only 50% of the revenues from exploitation of that music would be paid to the plaintiffs, with Embassy keeping the other 50%. The plaintiffs also agreed that Embassy could charge a 15% overhead fee on the production costs it incurred. That's set out in paragraph 2C. So why did the plaintiffs agree to these outrageous terms? Because they wanted to have their movie made and they wanted to get paid to write and act in it, and they had no other alternative to selling their movie to Embassy Pictures on the terms Embassy was willing to offer. They certainly had a choice, not get their movie made, and they decided that accepting tough terms from Embassy was a reasonable price to pay for getting what they wanted. And it clearly was the right choice. Spinal Tap helped to further their careers and set them on a path to great success, and in the case of Harry Shearer, unbelievable wealth. To try now to renegotiate those terms isn't fair to Vivendi, who took all the risk and is entitled to all of the reward from Spinal Tap, subject only to complying with its contractual obligations to pay the plaintiffs the amounts they were due under the terms to which all parties agreed some 35 years ago. The number 4 reason the plaintiffs also are screwed is, oh crap, I agreed to that too? Apart from the distribution fees and other terms set out in the main agreement, the plaintiffs also accepted language in the standard terms and conditions that, while clearly in dispute as having been subject to good faith negotiation, pretty neatly dispose of a number of their claims if Judge G decides to hold them to those terms. For example, the plaintiffs complained that Vivendi packaged Spinal Tap with other crappy films and then failed to attribute a greater share of the license fee to Spinal Tap, even though it was the most valuable film in the package. This is a common claim made by profit participants, which is not surprising because everyone thinks their movie is better than everyone else's movie, and it could be a decent argument if it were not foreclosed by an express term of the contract. Here, paragraph 5.02 says, among other things, that, quote, Embassy and any licensees or sub-licensees of Embassy shall have complete authority to distribute the film and to exercise the rights in the film herein granted in accordance with such sales methods, policies, and terms as they may, in their uncontrolled discretion, determine. Embassy will, simultaneously with the distribution of the film, distribute films produced by it or others or both, in competition with the film, and Embassy shall be under no duty to secure for the film as favorable prices and terms as it secures for other films produced by it or others or both. Whenever a licensee pays either a flat sum or a percentage of the receipts or both for the right to exhibit a group of films under an agreement which does not specify what portion of the license payments apply to the films in the group, Embassy may, in good faith, allocate to the film for the purpose hereof such portion of such total license payments as it may consider proper under the circumstances. Other than having an obvious affinity for the words or both, the Embassy lawyers who drafted this provision gave Embassy tremendous latitude to package Spinal Tap with other films and allocate the proceeds from those packages as it saw fit. If Judge G deems it fair to hold the plaintiffs to these provisions, their claims about Vivendi unfairly allocating license fees for film packages that include Spinal Tap should be dead on arrival. How much more dead could those claims be? None. None more dead. Finally, the number 5 reason the plaintiffs also are screwed is don't forget about the interest. Although it's hard to imagine such a thing was even possible, given the historically low interest rates we have today, the prime rate of interest in 1982, the year Spinal Tap was produced, was a whopping 17%. The plaintiffs specifically agreed in paragraph 13 of the main agreement that Embassy Pictures could charge them a rate of interest equal to the prime rate plus 2%, so 19% interest, on amounts advanced to fund the production costs for the film. So, since 1982, Vivendi has been entitled, in calculating the profits generated from its distribution of Spinal Tap, to charge 19% interest on the $3.5 million it paid to produce the film until such time that it received enough revenue to recoup those costs. That's nearly $700,000 a year, or $60,000 a month in interest charges starting in 1982, which is a pretty big monthly nut for the film to cover before actually generating any positive net profits in which the plaintiffs could share. Although we haven't seen any of the participation statements Vivendi issued to the plaintiffs, I wouldn't be surprised if the film never dug itself out of that hole, given how little money it made in its theatrical run and how long it has taken the film to generate additional revenues from other distribution. So once again, we see that the plaintiffs traded away any realistic hope they had of seeing a share of net profits from Spinal Tap when they signed their contract with Embassy Pictures by virtue of the interest they agreed Embassy could charge, without regard to whether Embassy or Vivendi later sold that film in bogus packages, made sweetheart deals with its affiliates, or both, as Embassy lawyers would like to say. This brings us to the end of part 1 of our program on the Spinal Tap lawsuit. I'm sure this case will be the source of more legal fireworks and humorous developments before it eventually settles, and we look forward to bringing you another installment of this program soon. Thanks for watching.